recording now.
All right, we're recording. Oh, it's transcribing. That's weird.
So I'll give a brief introduction. I do see a lot of familiar faces in here. There are some faces I don't recognize. So just briefly, my name's Josh Brown. I am the sheriff. I was elected in 2020 in the general election, sworn in 2021. I just began my second term, sworn in January of 25. I ran unopposed last year, which was nice because I got to keep my job, but also it meant that I could just work and not have to worry about campaigning. I started with the sheriff's office in 2005 as a corrections deputy. I moved to patrol in 2012. I worked at Sand Lake as the contract deputy for the Forest Service for 4 seasons, and then moved to regular patrol before running for sheriff. Of course, I'd love to be able to say more about me, but that was not what tonight's about. So I'm going to let Nick do a brief introduction, and then we'll get into it.
Yeah, thank you. Nick Troxel, City of Tillamook. I'm our chief of police. And so sometimes people honestly get the two of us, the titles confused. But as Sheriff Brown said, he runs for his position. I am hired by the City of Tillamook and appointed to my position as chief. And so I'm super excited that we're here tonight to be able to have this dialogue. It's something that I'm encouraged by and very hopeful that we can continue this kind of conversation. In fact, March 13th, Chat with the Chief is right here. So come on back if you want to chat more with me about stuff in the city. I started with the city police in 2003, worked as an officer, worked in the schools as our school resource officer, which is probably the highlight of my career, is working with our young people in community that way. I then worked as a detective, working all kinds of different crime, and worked a lot of time in our child abuse, working with our children again. Promoted to sergeant, promoted to lieutenant, and then promoted and hired as our chief. So thanks again for coming. I'm looking forward to this.
Excellent. So the title of this was Arrest, Bail and Release, Charging Decisions. We're going to try to stick on topic as best we can and go over each section individually. I probably won't take a full 30, 40 minutes. I like getting to questions because questions really hone in on what it is that you guys want to know. So I'll just try to give the best brief overview and try to go into some explanations. Chief Troxel will jump in when he hears something or believes maybe I'm missing something and has something to add to it. If there's a legal component, we may lean on the district attorney to clarify some things. So we'll get right to it. Arrest. Most everybody has probably either seen in person somebody getting arrested, or at minimum, they've seen it on TV. And there's a lot more to what arrest is, although that is part of it, the actual physical custody. But tonight, as we get into this, we're going to talk about the different types of arrest. We're going to talk about what leads up to the decision to make the arrest by the officer on scene. So types of arrest. And actually, I'm going to refer to ORS. As the night goes on, ORS stands for Oregon Revised Statutes, which layman's terms means Oregon law. Okay.
I'm just trying to, it keeps prompting.
Okay. So I want to give you what the ORS definition of arrest actually means. And I got to take my glasses off to read. I apologize. So arrest means to place a person under actual or constructive restraint, or to take a person into custody for the purpose of charging that person with an offense. That's what Oregon law defines as an arrest. So we're going to get into it a little bit, what constructive and actual means. Types of arrest are in custody. So where you actually see somebody get handcuffs put on and they get taken to jail. The other is cite and release. Cite and release is actually the common term. The better definition is citation in lieu of custody. There's lots of reasons why a citation in lieu of custody may be a better option as opposed to taking somebody to jail. And we're going to get into that a little bit. And there's probably going to be a lot of examples to try to help explain what some of that means. I found that examples tend to help people understand just a little bit better. So as we lead up to the decision to arrest somebody, there's a lot that goes into it, okay? So any law enforcement officer is going to get called out to a call by dispatch. And, call comes into dispatch. If you're in trouble, you call for police show up, deputies, officers, troopers, they go through the process. They start an investigation. That's the key point, is we have to begin the investigation. We have to look for facts, we have to look for evidence, we have to see who the parties are that are involved. And all of those factors start building the case or into the investigation, okay? Some cases are more simple than others. Some cases are far more complicated. You may have 10 witnesses. You may have 3 or 4 different buildings that have camera views that you have to take into consideration. The more serious the charge, the more complicated it tends to be. Am I kind of hitting the points here pretty okay?
Yeah.
Okay. So as people telling 2 different stories. So our job is to find extenuating, the additional facts that go along with it. For example, if we respond to, say, a disturbance and somebody says, well, that person hit me, and this person says, I didn't hit them. Well, one of the next things we're going to do is we're going to look at their hands. We're going to see if there's marks on their hands. We're going to look at the quote unquote victim's face or wherever they say they got hit, and we're going to see if there's marks. That would be corroborating evidence if those things exist. So those are the steps that we take. We'll even go further and we'll start looking to see if there's witnesses that maybe saw it. So if there's 2 people in a parking lot, you may have 3 or 4 people that actually witnessed the event, and then you can start communicating with them to see what they saw. Everybody has different perception or they perceive a particular incident differently. So the cop's job is to determine what actually happened based on all that information, based on potential for marks or maybe there's video cameras that can actually look into it. So just for something as simple as 2 people saying, somebody hit me, there's a lot that goes into it. Now, if a cop is able to see marks, they're able to see marks on the victim's face, they have witnesses that corroborate that they got hit, the cop now has probable cause. Probable cause gets us to the point where we're able to make an arrest, okay? So then the officer has to choose, what's the best course of action? Do I put him in handcuffs and take him to jail? Or do I cite and release? Or do I write a report and forward it to the DA and let the DA make a charging decision and then look for a warrant down the road if she decides to do that? So those are the options that they have to go through. In that particular scenario, that person's probably going to go to jail, because if they're still there and they just fought, we don't want to leave the scene and leave the 2 people with each other. So those are a lot of the steps that go into deciding whether or not somebody's going to be arrested. As we get into cite and release or citation in lieu of custody, a lot of people may wonder, well, why would you ever do that? Why not take them to jail? Jail has plenty of room. It maybe teaches them a lesson or something. But there's a lot of reasons why something like that would happen. The best example that I can give is, let's say we go to a crash and then we develop probable cause or at least reasonable suspicion to believe that the driver in that crash was intoxicated. That driver may be going to the hospital. That driver may be getting transported to Portland because of their injuries. We don't want to necessarily just let that go. So we actually will do a citation in lieu of custody, which gives them a court date and it gets their information and allows us to hold them accountable for those actions. That is a perfect scenario where a citation in lieu of custody would come in handy, because if you want to arrest that person and they're in your custody, you'd either have to stay with them, because you can't take them to jail because they're injured, and their safety or getting that medical treatment is far more important than actually physically taking them to jail. I'm trying to think if I've missed anything there.
No, the one thing, so that's a great person crime to consider and how we might look at that. But something else to think about, especially with we have cameras like everywhere now. And so people are like, well, didn't you see it on camera? If the person, let's say the person is in a car, it's dark, and they hit an object, or maybe they run into something, or maybe another car, and they're like, well, we know who the car is. Why don't you just go arrest them? Well, we may know who the car is, but the video wasn't good enough for us to see who actually was in the car. And so while it may be registered to me, It could have been, a friend driving my car. And so it's always an opportunity for us within law enforcement to be able to explain specifically to the person that may have property damage or they're frustrated as the victim, like, why are you guys not doing anything? Well, we are doing something. We just have to make sure we can positively identify that person before we were to move forward and actually take somebody to jail. In fact, we might collect all the evidence to be able to support the crime and everything we're looking at, but we're still going to send all that information to the district attorney's office for them to review it to make sure we're actually hitting that level. And they can then either take it to a grand jury or they could put out a warrant for the person. And so there's so many moving pieces, and it's not like watching a 30-minute TV show on a crime series, like, well, go put the information in the computer and it's going to spit out who did it. That would be really cool, but we don't have that kind of stuff.
And we don't have the fingerprint machines that you can just touch and get an instant readback. That does not exist.
It's not a thing. And so I love being able to have these conversations with folks and let them into our side, because you all have your professional lives as well, and you do your stuff, and I probably don't get it, and that's okay. But if I wanted to know more about it, I would ask. So anyhow, that's on that part. Probable cause, we need that. There's a difference between reasonable suspicion and probable cause. Reasonable suspicion gets us to that point where, hey, we've been able to develop the probable cause. So, yeah.
No, that actually, and to kind of expand on what he's saying, there's times or cases that may be complicated enough because you have to go hunt down extra camera views, hunt down, not hunt down, but you have to go find witnesses to be able to communicate with them. Sometimes the victim or the suspect have left, and so you have to track them down to be able to try to interview them. Investigations could happen right then and there, and a decision could be made, but they could also take days. And part of that process is we want to do our job absolutely as best and as perfect as we possibly can. We're not going to arrest somebody unless we have that probable cause, because we can get in trouble, for one, and for two, everybody is entitled to that process. We have to investigate to make sure that any potential allegations are verified and the probable cause exists before we go and take somebody's liberties away by putting them in handcuffs and taking them to jail. We take that very seriously. Plus, a good investigation builds a much stronger case for the DA to be able to work with. So we try to make sure that our investigation is as thorough as possible. We also want to make sure, and a huge factor in it is safety in that moment. If it is a fight, but all parties are separated and nobody's around, and then we have to go track down the other people, well, safety is not as much of a concern because the parties are separated and we're not worried about them getting back at each other. So there's a lot that goes into it. There's a lot of standards that we want to meet, a lot of important details that we have to make sure that we hit, so that way we have that solid case. And like I said, the constitutional protections that people have, we want to make sure we're not violating those, and the only way we can is a thorough investigation. So we talked a little bit about reasonable suspicion and probable cause. Reasonable suspicion is as low as it gets as far as a standard. It gives us the ability to look a little further, but ORS defines reasonably suspects as it means that a peace officer holds a belief that it is reasonable under the totality of the circumstances existing at the time and place the peace officer acts as authorized. So it's very vague, but it's just reasonably believes that based on the totality of the circumstances existing at the time. So probable cause, which is the next level up, means that a peace officer holds a belief that it is reasonable under the totality of the circumstances. No, I'm reading that same exact one again. I turned the wrong page. Probable cause means that there is a substantial objective basis for believing that more likely than not, an offense that has been committed and a person to be arrested has committed it. So it's a significant step up because it's substantial objective belief basis. Okay. Now, the DA is going to have to actually prove beyond a reasonable doubt. So that's another step above probable cause. So we're trying to do an investigation that's going to help the DA get to that point. But those are the standards that we have to go through. And you'll notice that I'm reading a lot off of ORS, Oregon law, because everything that we do is governed by Oregon law. So I can't think of much else about actual law, or excuse me, about arrest. So moving to in custody in the jail. One of the big reasons that I wanted to have this event is because there's not a lot of people realize this, and maybe some of you are aware of it, but a couple of years ago, I think one of the sessions that Oregon legislators had, they got rid of the bail system in Oregon entirely. Well, not entirely. There are some places for it. I think Measure 11 crimes they still have a bail attached. The judge has the ability to attach a bail if after arraignment or to a warrant. But generally speaking, if a person gets arrested, prior to the legislators getting rid of this, what would happen is you would come to jail. Every crime level, A felony, B felony, C felony, A misdemeanor, B misdemeanor, C misdemeanor, had a set bail amount attached to it. So for example, an A misdemeanor was $3,000. A traffic misdemeanor like a DUI was $5,000. But if you got arrested on an A misdemeanor and you came into jail, the bail was set at $3,000 just as a standard. In Oregon, we don't have bail bondsmen, but what you can do is post 10% of that and you can get out of jail and you have a release agreement, and then you have a court appearance that you're expected to go to. The ability to pay $300 or 10% of an established bail no longer exists in Oregon. That's gone. Instead, what's been replaced is what's called a presiding judge order, and that presiding judge order had been dictated from the Chief Justice of Oregon down to the lower court judges, and they have to put a standard for pretty much every crime in Oregon that says if you've committed this crime, you stay in jail until arraignment. If you've committed this crime, you may stay in jail. You may not. It depends on the circumstances. And then if you committed this crime, you're automatically released if there's no other charges or extenuating circumstances attached to it. So it's probably a 20-page document, I think, that lists all these different crimes and different scenarios that you're supposed to go through. So if you come into jail for a theft 3, let's say, which is a very, very low level crime, if you have no other charges attached to it, you're going to come in, you're going to get booked, you're going to get fingerprinted, picture taken, all the paperwork's going to be processed. But then according to this PJO, it says release, and it'll say release under this release or this conditional release agreement, and marks down which conditions you're supposed to actually do. So a person may be charged with theft 3, they go to jail, but per the PJO order, we're required to do all this process, fill out a release agreement, and boot them out. And so that's why you see a lot of people getting released on a more regular basis, because that PJO is directing us to do that. The court also has, and I'm not going to get too far into, I don't want to speak for the court, but they have 2 employees that are actually release assistance officers, and they come out to the jail all times of the day, and they go through and they meet with a lot of people that actually are required to stay in jail. And there's a process that they go through to determine if they meet the criteria to be released. And then the judge may order that person to be released based on information their release assistance officer got. A lot of people don't understand or know, like I said, that bail is gone. So people aren't held in jail waiting for arraignment or to post bail. They just may automatically be released per this presiding judge order, which again comes all the way from the Oregon legislation mandating it as law. Does that make sense? Did I kind of hit those points?
Yeah, and I just want to make sure everybody understands that, because these are the phone calls we get at our office. I'm sure sheriff's office and other police, or even state police, they get these questions. They get a phone call saying, wait a minute, you took them to jail and now they're out. I didn't see them on the roster, and they're all steaming upset at us, and that's okay. We'll listen to it. But then we'll try to explain the process. And sometimes it's not, as you just heard from the sheriff, it's not that easy to even describe the process. And the person is so upset that they're not really hearing what we're saying. So again, this is another opportunity for us to be able to explain that system, and it's new to folks. And so it's not a decision we're making. The sheriff's not making the decision. It's out of our control. We're doing our part of the job. Law enforcement is, the DA is, and the courts are doing their jobs. But that's just something that we have to remember, is that we have to follow the process.
Perfect. Yeah, like I said, that PJO directs us. In fact, when the legislation went through and did this, one of their goals was to take discretion away and treat everybody equally across the board. So that way there was no chance of discretion of officers or release assistance officers or anything It just literally was, ask these questions. If these criteria are met, then release that person. So, and if it's not met, hold them for arraignment. The judge may come in during arraignment, which we have a couple different options for arraignment. It can be done by video, or that person can be asked to be in person. But then the judge decides what happens to that person after that. They may set bail. They may actually tell them to be released. They may continue to hold them and set another court date. But as Chief Troxel said, once they come in, we have this document that we are required to follow, that as we follow, and it says 1, 2, 3. If we get to 3 and it says release, we release. If we get to 3 and it says hold, we hold. So that's kind of where we're at on that. And that's, like I said, that's a law that Oregon had passed. And so we don't really have much choice, because the one thing that we're going to always do is we're going to follow the law. I know that somebody had already mentioned, I think, that oh, we got somebody trying to come in.
I got it. Did you get it?
I did not get it. I just touched my phone. Sorry. It's similar. There's a lot of conversation, and I don't want to get too deep into this because it is a little off topic, but the federal government, the immigration law, and I've been getting a lot of questions about what our stance is on that. And the simple answer is that Oregon does have laws that prohibit us from participating in federal enforcement of immigration law. So we're going to follow that law. We're not going to participate or assist with federal agencies to do that, because we're going to follow the law. That doesn't mean that federal agencies can't come in and do what federal agencies are going to do, because they have the right to adhere to federal law. We're not going to assist them because we are prohibited by Oregon law. So the simple answer to that is that we're going to follow the law when it comes down to it. So in a similar fashion, when the PJO says release, we have to follow that law and with that PJO. So that hopefully will give you a better idea of why you may see people getting released on a little bit quicker or regular basis. It's because of that. So Garrett, that's actually all I got. Unless you have anything to add, we can move into questions.
Okay, I think the best way to do this, I'll go on this side, and then I'm just going to go right through the rows. So if you got your hand up in the front row, ask a question, I'll just move back. Okay, we'll start with you, sir. Go ahead.
Thanks, guys. I'm a homeowner and soon to be 19 more days as citizen down here voting, and I appreciate your guys' servitude as road dogs too. It makes me feel good to know that you guys are in these positions.
Thank you for saying.
And I'm going to ask. I'm asked the same question of you, Adia Olson. What do you guys see? We've all been troopers, deputies, officers. When you're door to door talking to your troops, to your partners over these years, you guys have had plenty of years on. What do you see as the biggest demotivating factor in officers, troopers, deputies? What do you guys, in your opinion, what do you think is the single most demotivating factor in a law enforcement officer's everyday life?
That's a good question. It's kind of tough. I mean,
I've read several articles, and you've actually, I shouldn't even ask you because I already know your answer.
Yeah, it's I don't know if I could give any one answer. I mean, the landscape of law enforcement is changing.
Yeah.
Law enforcement 20 years ago when I came on looks entirely different than what it looks like now. 10 years ago, it was different. The younger generation of cops are being cops in a whole different light, a whole different scenario, a whole different society. Their viewpoints are different. I can tell you one of the hardest things for me is learning to adapt to them, because they are the future of law enforcement. But there's just the whole laundry list of things. I don't know if I could narrow it down to one.
Think about the back when you guys were door to door having your coffee with your partners.
Well, I would say there's so much confusion at time, and I would defer to two of our officers there in the back here, and there's some sheriff's office staff as well. But there is so many changes that come down the line, like, oh, well, you can stop a car for this, but you can't stop them for this. Or you can arrest for this because we're going to do, I don't know. I mean, it is almost daily things are making adjustments and changing. But I think that if we have good community support, that we can work through these things as well.
Are you on
But
now?
that's the hardest thing for me, is making sure that
Oh, you want to sit
we're
here and
getting
watch
the
it with me?
information out to our team at the police department, that because ultimately I have to answer for every one of our staff, and it's all on my shoulders. And so I'm constantly either working on my own professional development, reading a lot on stuff that comes out of Chiefs and Sheriff's Association. And so I would say that for me, as I progressed through my career, that's been the kind of the downer, is like all the different changes and stuff. And especially when we had adjustments to our drug laws, like that was a real shot in the gut.
So in the interest of time, we'll just keep going. Lady in the green shirt.
I have a
Hopefully I didn't dodge your question.
And I'm not trying to cut anybody off. We'll go back if we get through everybody, but I want to make sure everybody gets a shot. So go ahead.
So I know you're in Tillamook and I live in Nehalem. But what's the difference between what you guys do in terms of your job between a police officer and a sheriff? I'm sorry, I'm very naive about this. I should know.
So the sheriff is elected, and they have, well, I'll let him talk to that. The police chief is hired by the city. So I'm responsible for the city of. And so there's a total of 10 sworn police officers, including myself, for the city of Tillamook. And so I lead and manage our police department within the city of Tillamook. We also have administrative professional staff, plus we have code enforcement. And so that is my responsibility. I answer to our city manager here in Tillamook, which we have an interim right now. I answer to him, and ultimately that person answers to our mayor and council. And so that's how our government is set up in the city.
But if I call 911 and you guys are busy, does the sheriff then respond?
Oh, no.
Or did
We only, yeah, good question. We only respond within the city of Tillamook, so we're responsible for those calls for service. Now, if there's an emergency in the Nehalem and they need help, and we will obviously go up there.
Our law enforcement Tillamook County partners very, very well. OSP will come back each other up. We've had Tillamook City come well outside of their jurisdiction. We've helped them inside. I think very broadly, to answer your question, there's really not much difference. We're all certified through the same agency. We all carry the same certification. We have the same training requirements. We perform the same duty. We have the same authorization, to enforce state law. Probably the most clear difference is just jurisdiction.
Okay.
That's probably the biggest one. We're generally not, they're going to be doing enforcing city ordinances, but other than that, they're enforcing the same exact Oregon laws that we're enforcing. They have the same authority as we have. And realistically, it's just jurisdiction. But in Oregon, every law enforcement officer has jurisdiction across the entirety of the state. So if I'm over in Eastern Oregon doing something and I witness a crime, I could in theory act. The only difference is that when I act, the venue for where that crime occurred changes. So we carry that same authorization and authority across the entire state. So really, to really make it simple, it's jurisdiction.
Okay, that's clear to me. Thank you.
Go ahead, Teresa.
For Tillamook, the folks incarcerated in our Tillamook jail, do we have education, trade skills building, and or treatment options so that maybe we don't see
All of the
same
all of the
names
above.
on?
We do. So we have an inmate worker program. Our parole and probation commander, and that department gets a whole series of grants to fund. And part of that funding, there's elements of that. And so we actually, a couple of years ago, created a program that we call Brighter Futures, that it has elements of getting your GED or college classes. So we have partnerships with TPCC. We have a program set up to try to get food handlers cards so that when somebody gets out, that food handlers card could be a benefit to them. We have kind of an interview and resume building type of a system to where these inmate workers that come in, we can actually work with them a little bit on that. We recently contracted with a company, I don't know, it's been a couple of years, I guess, where we actually have iPads that we use for legal services, Bible studies, visits. They can actually visit through that. But on there's also some resources that can benefit or help do those kind of things as well. So yes, to answer all those questions, and we have a great partnership with Adventist Health. And so they as well as TFCC. So if we need treatment or if we need mobile crisis, that type of things, those are all very accessible to us. And we are actively doing all of those.
Excuse me, can you restate the questions? Some of them we can't hear all the way.
Okay, yeah, I'll speak up. Sure, you got that. Okay, we'll go down here. Nobody will go up here. Green vest.
I have,
Hang on one second. Did you not hear her question?
I wasn't real clear on what it was, but I figured it out.
Okay, she was just asking if we had programs in the jail that could benefit. So, okay. Sorry about that.
I
Yes, ma'am.
have one question about arrest and release.
Okay.
If they go to court and they are sentenced to 6 months, can they
Okay.
still be released?
Being sentenced is different than being,
Will you repeat the question now
Oh.
so they can hear?
you got that one. Okay. So the way that, so there's pretrial or
Yeah.
pre-sentenced. Those are all people that are not convicted or sentenced.
She was
The,
convicted.
huh?
She was convicted to 6
So
months.
if somebody who's convicted and they're sentenced to 6 months, they stay in jail, I don't want to say there's options. There's potential for release because if they're working with TFCC or something like that and the sentence order allows for treatment, like if a treatment bed becomes available, they can be furloughed out to go to a treatment bed. If there's a serious medical condition, they could be released for a medical condition. But generally, we don't see those a lot. A lot of what you may see, if somebody is going to get released because of when they're sentenced, they're going to be going to probably to a treatment bed and they're going to get day for day if they successfully complete that.
She was released 2 months and was dead 5 days later.
Very sorry to hear that.
There's good time. I don't mean to.
She didn't do her full 6 months, and if she had.
Well, 6 months isn't going to relate down to 2 months, but
I can speak more to that if you want me to, or I can, when it's my turn.
okay, yeah, that's fine. That's fine. There is, like DA Olson just mentioned, there is good time and worker time or something like that. I don't know why this person would have got released, so I couldn't speak intelligently to that. But 2 months on a 6 month sentence would be a little bit more than good time. So without knowing the exact situation, I couldn't speak to that intelligently, but
You have about 15 minutes in this session. Corey, go
I have
ahead.
a question.
sure.
You brought up the tablet iPad.
Yep.
Do you monitor those and the conversations that people have on those with the outside public?
Yes.
And if somebody, the person she's actually talking about is openly having conversation with someone on the outside about, I can't wait to get out and have it ready for me.
So we
Loaded
don't, we don't
syringes.
have enough staff to sit there and monitor every conversation of every minute. A lot of it is conversations. If something happens, we go back and look at it from a different viewpoint or look at it like,
I guess my question
Okay.
is more of,
45.
if this person is getting good time, they're on that job, I don't remember what you called it.
in the worker program.
Yeah. And so they get out super early because they've done these things, but yet they're having these conversations. How is that not revoked from them?
Well, I guess a lot of it depends. So if they got released in a 2 month time frame after being sentenced, and they got all this good time and they got worker time, if they didn't get released to go to treatment and maybe when they got sentenced, they got credit for time served. And so maybe they sat in jail for 2 or 3 months while their court process was going, they get credit for that. As soon as a person's sentence is up, we have absolutely no legal authority to hold on to them anymore. So that's one aspect of it. If we hold them, we are violating their constitutional right and we are violating the law by illegally holding them. If somebody is making threats of suicide or self-harm or something like that, we can ask that TFCC send out their mobile crisis and either speak to them before they get released or try to speak to them as they're being released. If they're talking about using, I can't keep them in jail because I'd be violating their rights. And I can't necessarily follow them or arrest them if they're just talking about that. Because
Understand that.
if we go and we confront this person and say, hey, you were saying this, all they'd have to do is say, no, I was just trying to sound cool in front of my friends. Now, clearly what happened was a tragedy and I'm not trying to make light of that. But at the same time, there's things in place that we can't violate, if that makes sense.
When somebody's earned good time, is that something that can be taken away by those
Not
types?
legally.
Okay. I don't understand. Thank you.
Got time for another question here before we switch gears. Remember, we got more time out there for questions, so we'll just keep continuing. Go ahead, you want to?
Okay, so this is for Nick Troxel. I'm here on a different matter, and so I'm hoping that maybe on the 13th next week, this can be discussed about safety in downtown.
Mhm.
And I guess just testimonies and working in an establishment downtown and we're not safe. And so if that could be touched on next week, because it doesn't sound like that's our topic.
No, that's an excellent spot for it. In fact, that conversation started at council last night.
Okay,
And so I'm encouraged by the energy surrounding businesses
okay.
wanting to have that conversation. We at the police department want to have the conversation. And
Should
so,
we be attending the city council?
no, well, I mean, the mayor's here. I mean, you're more than welcome to attend city
Is
council.
it an open forum to
No, it's
share?
really not. No, I mean, you could provide comment,
Okay.
but we would, most likely, I would connect with you afterwards, like
You
day
have
after.
right, you already have an agenda.
You
Yeah.
can comment on anything on the
Sure.
agenda. There's a separate part where you can comment on anything off the agenda. So you can comment on anything you want at a city council meeting. It's just, there's two separate sections. And we've never not let somebody comment.
No, I mean,
Welcome to come.
but looking forward to it. Yeah.
Okay, well, we got more time than I thought. We actually have closer to 20 minutes. So let's continue to go this road. Okay, go ahead, ma'am. White shirt.
You,
Let's do white shirt. Just go
Okay.
like this. Yeah.
Okay, I'm going to, my question is to, on what they talked about.
Okay.
Okay, the iPads that are provided.
Mhm.
My question is, why are there other programs or applications on that iPad in which this inmate is able to talk to the outside people? The programs you have on the iPad should be for the programs that you're helping them to get better with the Tillamook Center, so.
I should have
So the
clarified.
question
Okay.
is, so people can't hear, the question is a little more clarification on the iPads at the jail and what they can provide and what they can provide, kind of is what.
Yes,
Okay.
yes.
Right.
So I apologize, I should have clarified. The iPad is for programs, it's for visiting, it has that type of stuff. The same company that we contract with that actually provides those, we also get little crickets. They're basically small cell phones. They're in a hard case of the iPad. Those phones are what they use for actual communication. They can send text, they can actually talk on the phone and stuff. So they are two separate things. And the iPads, and I apologize if I don't know every last detail of what it is that each one of them does, but I believe the iPads is where you do visits. There's also stations in our housing units that actually allow for people to sit and not be on the iPad to do visits. So
Sure.
generally speaking, the crickets are for communication and the iPad is for resources.
Okay, so the crickets, the inmates have all the time
Yes.
and they're able to.
Yes.
Okay, so do you see my issue there? Not only.
They
with
shut off at a
nowadays,
certain time though.
But it doesn't matter the time. I'm concerned about the people that are addicted. I'm concerned about
Okay.
pedophiles. Like there is a lot of information that you can, on that cricket text.
No.
As Corey.
No, you can't actually access any of
You
that.
can't
There's-
access it. Okay. then
No, the
how is that?
company is specifically, they specifically cater to correctional facilities and all of that stuff is completely blocked. It is isolated. It does not have access to the internet, anything like that.
And my question to be is then, how was this young lady's sister able to send those messages to the outside?
Are you talking about messages of words?
Yes, or
Okay.
however.
Well, I
Sorry, yes.
I think I know what you're talking about, and that's under investigation. So I want to be real careful that we don't tread into anything that's in like.
Absolutely.
Under investigation. Definitely happy to discuss some of those issues if it relates to an active investigation. I didn't mean to step on you. I just was like, I felt like this
I
was
wasn't
starting
aware of
to
that,
move
yeah.
into a territory that I know we're working on, and I don't want to get too far into it.
Thank you.
generally speaking, we want to still make communication with loved ones on the outside still available for people.
Absolutely.
And I don't want to completely eliminate that. So we do have protections in place, but that does not necessarily mean that somebody still can't get a message that may not be completely appropriate through.
Absolutely. Are those monitored though?
Like I said, they're not monitored every minute of every day. I mean, if we have, 40 inmates in there and they're all on their phone at the same time, we cannot monitor them constantly. So That's just impossible.
All right, we'll move on to the next
Okay.
question.
Thank you for your question.
Two short questions. What prompted this meeting and who put that new document? Who was in charge of preparing that new document?
Which
What prompted the meeting and who was in charge of the document?
The one you were talking about,
The presiding judge order,
Yes,
the big one.
yes.
So what prompted this meeting is two things. One, I've had on the back of my mind that I want to figure out a way to explain to the public the best I can that the Oregon bail system is essentially gone. The second thing was a conversation that TA Olson had that she was sharing during a meeting with somebody in the public. And so I emailed her, I said, we probably need to do a town hall that looks like this. That was on her mind. Next thing you know, we had the meeting. The PJL order comes from state law. State law designated or directed the Chief Justice of Oregon to send out a presiding judge order to all the lower judges, and then all of the lower judges for each individual county created that document. So they are following the Chief Justice's order. The Chief Justice is following Oregon law. So every county has a presiding judge. So even if you have multiple judges, each county has a presiding judge. So that presiding judge is the judge that created that document.
So what would have prompted the Chief Justice to prepare some?
Oregon legislation changing the law, eliminating the bail system and directing the Chief Justice to create this document.
It's like senators.
Senators, representatives, yeah, Oregon lawmakers. Yes, you're welcome.
Do we have any more questions in that row? Okay, let's move back here. So you have any questions in this row? Here we go, Ro.
So first of all, thank you for following the rule of law around Oregon sanctuary law. I appreciate that a lot. That's the biggest reason I came here. Second, thank you for doing a really difficult job of trying to uphold that rule of law and have accountability and balance that out with dignity, the people, for the whole community. My question is around two of the biggest concerns that I'm hearing in our community are around public safety downtown. She had mentioned there's a lot of people that are really struggling with mental health issues, with addiction issues. And with that, the other thing that I'm hearing a lot about and has touched my life personally is addiction. And too many people are losing people they love in this community. People are dropping dead. And it's terrible. And I'm not saying that you guys can do anything to fix that, but I'm saying that I know there's programs like, and you're probably going to roll your eyes, the Cahoots program in Eugene, which is well-staffed and they have a lot more money than we do. And I completely understand that. But I'm wondering if there are things like diversion programs in the courts that can help people get into the help, since there aren't the sentencing laws that would help with that accountability that gets people into treatment. And also, are there programs being developed that can meet people in crisis on the streets? So you have a crisis team that's going out and responding. So you're not, maybe you can't arrest that person, but maybe they can get connected with resources they need and they can be safe and the community can be safe. So I'm wondering what kind of conversations are taking place around that so that we can uphold dignity and keep people alive long enough to get them the help they need and keep the whole community safe.
So I'm going to refer the diversion in the court process to the district attorney.
Okay.
As far as conversations, I would say, yes, there is. And I'm assuming you know the person sitting right next to you. I quote her quite often, and I'm probably going to mess this up, but Oregon is still 50th in the nation for addiction treatment.
Yep, access.
And the reality is no matter what conversations that we have here locally, no matter
Close in 5 minutes. Is now time, start heading toward the end.
no matter how much work we try to do. Right, it sounded like an airplane. No matter how much work we try to do, and I do believe that we have things in place that TFCC has a mobile crisis team, and they have been amazing since the creation of that. If somebody's in mental crisis, we can call them, and if we need them to be on scene, they drop everything and they're there. We've had them come out to the jail numerous times, so that is a great resource. I know both TFCC and I think CARE has peer support teams, and to what level they do, I'm not certain, but they're there. So there are conversations about that kind of stuff happening because we recognize that. What I was starting to say is no matter how much work we do here, we will always hit that roadblock because there's not enough treatment in Oregon for addiction. Honestly, there's not enough treatment available for mental health. Are we 50th in that one too? Okay, she doesn't know.
It's just access to treatment, I think, across the board.
Okay. So when you're 50th in the nation, but like second in the nation for drug problem,
Treated addiction rates.
that's right. See, she can correct me. I literally quote her all the time, and I even asked permission when she finished her. Right.
Yeah.
Hi, Rachel Poljeski, she, her, princess pronouns. I used to be the Tillamook County Community Health Center syringe exchange harm reduction person. I now work for Folk Time. We're peer-run, peer-led agency out of Portland. However, I still live in Manzanita. I'm still a resident. I'm still doing a lot of work here. We just trained 10 peer support specialists, people with lived, loved experience. In February, we have a training next week for 20 more. I still have seats available if anyone is interested, but it's intentional peer support. It is another person to walk alongside someone who's been there, done that, who gives people an alternative. It shows that recovery is possible and it's beautiful, but it's also non-judgmental.
I didn't mean to call you out.
That's good. Yeah.
Like I said, I have been repeating the information that she gave from her time at the health department, or at the health department. Because that's a staggering fact that Oregon is, like second in the nation for drug addiction, yet we're 50th for treatment options. So having that access is terrible in Oregon. And quite honestly, that's step number one. And I've actually been pretty loud about that Oregon needs to step up and create some treatment facilities for that, mental health as well as addiction. It sounds like she's still doing great things. So thank you for that. I didn't mean to call you out, but at the same time, you did excellent.
I will add former nominated citizen of the year also. Do we have any more questions?
I want to make sure that there's a piece of Romy's question that I want to make sure that is answered, is that there's conversation and there's good work being done in regards to forming a county-wide crisis intervention team. And that team will be people from within community. It will be people who are peer support, clinicians, law enforcement, who are all trained to respond when in crisis. But also what I really would like to see is when, like Officer Lothman, he just walked by with somebody, we are also working to prevent them to get into crisis, and especially people we know. We talk about downtown and feeling unsafe. There's a number of people who if I didn't know who they were, they would make me scared. And so that's why I want to have these conversations about these folks who are community members as well, and how do we live and coexist with them and understand them and their story. But we're all safe and we're keeping a safe environment. We're not letting them break the law. Like if you do crimey stuff, you're going to get a crimey response from us. We're going to take care of it. So anyhow,
5 minute mark in this session. Do we have any questions here in the end? We'll go right here, down the road. I got one down there. Go ahead. Oh, sorry. Back here, okay?
No skipping. So my question's probably for Josh, but possibly for Aubrey. I'm back to ICE. And then another little sidebar on the federal funding for these programs that are in place right now and possible programs that you guys are talking about. Is that something that's going to go away, or do you have any?
I have no idea. Everything is fluid. It seems to change on a regular basis.
Okay, so my ICE question is, because I used to work with the DA, I didn't know about the bail thing happening, so I'm out of the loop. But it used to be that if somebody who was not here legally and they had committed a crime, that law enforcement was supposed to call Portland or Seattle and tell ICE that we have an illegal immigrant here, they've committed a crime, come and get it. Is that still?
Well, no, that is not still. And it did used to be, and it wasn't quite as blunt as that in the sense of, we have an illegal immigrant, yeah, come get them. It was notifying them that we have somebody who potentially was born outside of the country and is not, there was a form and everything. They would conduct the investigation to determine whether or not they were an illegal immigrant or not, and then they would make the decision on what they were going to do. We simply informed them with a form. But no, that no longer happens.
So you guys don't call and say?
Nope,
because
not allowed to.
My real question was, this kind of goes in the back of my head. If somebody's driving down the street and they get pulled over because they ran a light, is that suddenly a crime that they could get deported for?
Well, I guess it depends on, if a federal officer pulls them over, then maybe. But we do not have the authority to enforce federal law. We only have the authority to enforce state law.
But you see where I'm going, right?
I do. And there's a lot of, anxiety because of that, because people assume that Oregon cops are going to come up and see that person and take action on them. We have no authority to take action. We can't. There's nothing that we can do. And if we make a phone call, we can actually get into trouble, a lot of trouble. There's a system that tracks all those things and takes reports from that. That's why I say very adamantly that we follow the law, and the law forbids us from taking part in that. But on the flip side of that, if we pull somebody over and we suspect them as being illegal, there's literally nothing we can do about it. We cannot enforce federal immigration law, and there's no immigration law in Oregon. In fact, there's the laws that prohibit us from actually taking part in that. So we have no authority to do anything about that, even if we suspect it. We don't even have the right to ask them if they're here legally or illegally.
Gonzalez versus Clackamas County.
Is that the case? Thank you. I like that you're sitting up front.
I think what we'll do is we'll start on this row after the DA Olson's part, and we're kind of halfway through the group and we're halfway through the thing. So we'll let District Attorney Olson take over now.
Okay. Thank you.
All right, I've been running computer duty, so
I can switch over.
Gary, you wanna, in case somebody's late, although I was saying earlier, I might just be like, you're late. Denied, I'm not letting you in. Hey, y'all, I'm Aubrey. I am the district attorney. I've been at the DA's office for a little over 6 years now. Before that, I've been in Tillamook for going on 9 years. Before that, I worked for the Oregon State Police. I was a fish and wildlife trooper here in Tillamook. I did about a year in patrol over in Portland, where at one point I was the leading trooper in the state for crash investigations. It sucked. It was awful. I hated it, but I know a lot about traffic law. I spent my first 3+ years at the DA's office as the lead traffic investigator, or prosecutor rather. I did not go to law school because I loved Deweys. I hated them. I was a police officer back in Memphis, Tennessee, where I'm from, for 6.5 years. Decided I wanted to go to law school. I cared a lot about the environment, natural resources, animal law, things like that. I hated Deweys. And then I come to work at the DA's office and Bill Porter's like, Deweys. Love it. But they say if you can try a Dewey, you can try anything. And that is the honest to goodness truth. I have definitely learned that because everything stems from a stop. They stop people, or there's a crash or something. And one of the biggest issues that we fight about, figuratively, not literally in the courtroom, but we really argue about whether somebody was lawfully stopped. Were they lawfully seized? Was there a lawful search? So I'm here to tell you my oath, the very thing that I stand for, is that I uphold the constitutions for Oregon and for the United States. If those two, if they make changes that effectively make those two at odds with each other, I'm in trouble because I have to uphold them both. So that is my number one job when I tell people is I enforce people's rights. I enforce constitutional rights. I don't care what side you're on. Are you accused of committing a crime? Are you a crime victim? Are you just a citizen? You have constitutional rights as a citizen of this country, of this state, and it is my job to enforce those. A lot of times it's my enforcing those rights that piss people off. And please excuse me, I'm kind of blunt and I get told that a lot, but I'm not in court right now. And while I may be recorded on this, I don't have to worry about Judge Hill throwing me in contempt. And I learned yesterday he will do it on the way. Do not cuss at Judge Hill. You will spend 30 days over there on Long Prairie. It's kind of awesome to see, actually. Anyway, but seriously, people, I wanted to have this meeting, mention it at our leadership team meeting. We have monthly leadership team meetings over at the county, by the way, for those of you who are interested in attending public meetings and wanting to know what we're talking about. Those are recorded, those are by video. So if you're super bored on the first Monday of the month, tune in. Sometimes they get interesting, especially when Josh is there. Josh likes to heat things up.
Leadership meeting.
Anyway, but seriously, I had a conversation. A local business person here in Tillamook called me because their business keeps being, Garrett, you're not paying attention.
I'm answering a question about the thing on the.
But we have local businesses that continue to be victimized. And some of them are what have been coined as quality of life crimes, criminal trespass, disorderly conduct, things like that. And they're low-level crimes, but they're the people committing those crimes, and those are the people you're seeing that make you feel unsafe because they're always around, and what can we do about it? And this local business owner was like, I am so sick. I have trespassed certain people. They come to my business. I call the cops. They shoo them away, but they don't take them to jail. You know, what's going on? And then nothing's happening. That's what I keep hearing. Nothing's happening. Nothing's happening. And so we had a really long conversation where I was able to explain what's happening or why isn't something happening. It was very enlightening. And I wanted to share that because we have had so many changes in the law in recent years. Then it really has created a very palpable effect here in our county. And all of you are like, what is going on? Why are we not doing this? And those of us, at the DA's office, talking with the cops, we're like, what is happening? So we feel it too here. But I want to talk about this, not to just bitch about what has changed and why we can't do what we used to do, but how we are moving forward, what we're doing to work with a system so that we can protect the public and we can try to fix it. Now, sure, we're on the back end. I'm the last to know of anything that's happened. I'll hear the sirens going on, and there's like a certain level in my brain when I'm at the courthouse that I hear enough, and I'm like, uh-oh, something's bad. It's like 3 or more things went by, or I see multiple agencies, and I'm like, uh-oh, somebody's gonna call us at some point, let us know they need our help. But anyway, so one of the big things is, I thought the arrest thing was important. And these two are so polite and nice. They didn't say the one thing that I think you all were thinking is when it comes to arrest or, what are they upset about? Well, why am I going to arrest if the DA is not going to do anything? DA is not charging them, so I'm not going to arrest them. Okay. Well, and I didn't ask him about this. I was hoping they would touch on it, but they are peace officers. They enforce laws and they keep the peace. There are mandatory arrests in statute and there are discretionary arrests. Garrett, pay attention. So
I could work in the DA office.
I've been told my expectations are too high. Anyway, but some of these things that, like, let's say somebody's trespassing, you've trespassed them from your business, because that's the example that I just brought up. Well, the officer's not required to arrest a person for trespass. That's what you expect. They're breaking the law. Take them to jail. Sometimes they want to arrest. Sometimes that's the only way you stop it from happening. A disorderly conduct where you've got some dude laying in the middle of the street for whatever reason. We see that a lot actually. Some dude laying in the middle of the street, not moving, and they can't get him to stop. The only way to get that to stop is to take them to jail for disorderly conduct. I might not charge them for certain reasons, but that should not affect the officer's decision. It has no bearing on their decision of whether or not to take somebody to jail. Their decision power is within the law on when they can or cannot arrest somebody, which they went over very well. So I hate to hear that the cops are making arrest decisions based on, well, we don't think the DA is going to prosecute. I have not come out with a policy that says there's not a particular statute that I'm not going to enforce. That's not true. I did have a deputy reached out to me about some really obscure food safety law. I think it was a food safety law that's really obscure and really low level. And somebody was upset about it and wanted us to charge them criminally. But when I looked into it, there were a lot worse, more effective administrative penalties. And I was like, you know what? I don't know that this is really worth us using our resources on. So why don't we not charge that? So there is that one thing. I'd have to go dive through my emails to figure out what that is, but I've not heard anybody else complain about it. So I doubt you're worried about it. But I have not. There is not a single statute that I've said, I'm not prosecuting that. Everything is circumstantial. It's case by case. What are the facts of this case? Now, this actually is going to lead into one of my other topics is a lot of what we see. One of the other really big changes in the law over the last couple of years is that there is the release law. Sure, they go and they get booked and they're released. And so, we invited the Manzanita chief to come, but I don't know, he wasn't available or something. But they take people to jail all the time, and I mean, they'll tell you, well, it takes a lot longer to get back to Manzanita from Long Prairie than it does to get back to Tillamook. So a lot of times, sure, they don't care what my decision is going to be. They got them out of town, and it's going to be a few days before they come back. I'm just telling it like it is. I was a police officer for a long time. When I worked in Memphis, I knew cops that used to drive them across the bridge into West Memphis, Arkansas. That was like, I don't want to take them to jail. I don't want to do the paperwork. So I'm just going to carry them across the bridge. They got in trouble for doing that. It was really frowned upon. So, it is kind of a thing. They take people to other jurisdictions. Like, you deal with them now. They work their way back. I have definitely learned, and I'm always surprised by that when people, like, I'll see people who are, they got pending cases in Portland and then our case here. I'm like, how are they getting back and forth? Are people buying them bus tickets? Stop. Anyway, but one of the big decisions, so there's the release law that was talked about, why people might get out and you're not expecting them to get out. And that's pre-trial. That is a pre-trial situation where somebody gets arrested, and before I even look at the paperwork, they're out and they have a ticket, or not a ticket, but like a release agreement says, come to court in 3 days. And then I get the paperwork and then I make the decision, am I going to charge this? And I'll go over what that entails in a minute, but I did want to touch on one of the big changes in the law has to do with sending people to the Oregon State Hospital for aid and assist. Now, bear with me I'm going to try not to bore you or get in the weeds. One of the big things in order to file charges on somebody, if we file criminal charges, and let me back up really quick to explain something, because I've noticed that sometimes there's misnomers. The police often use the phrase, I charged them with a crime when they put them in jail. Technically, they're holding them on charges. They don't actually have any authority to file charges on somebody. Those people are being held on particular charges. The power to charge people rests with me and the grand jury. Now, I can do all misdemeanors without the input of the grand jury, but all felonies have to go through the grand jury. Now, I'm not doing a law class here, so I'm not going to go into the weeds on that, but just know that big cases have to go through the grand jury. 7 people. Some of you may have been on it. Some of you will be on it. We have a good time. We bring snack. Well, sometimes there's donuts, but not every time. Anyways, but it does go through the grand jury where they hear the evidence and they have to weigh it out. And our job is just to advise on that. But that process has to happen in order to formally charge somebody with a crime. So we review those, we go through it. So they're held in jail pre-trial, pre-charging, and that's the release criteria that they were discussing and why somebody might get released, an hour. You see them back at home an hour after they just went to jail, and you're like, I don't understand. So sometimes we see people, and if we're going to file charges, or if we do file charges on them, the number one thing is a person has to be able to aid and assist in their own defense. If they are not competent, we say aid and assist or competent to stand trial. If they are not fit to proceed, then we don't proceed. We might file those charges, but we don't proceed. And one of the underlying things they look at is the person has to have a mental diagnosis, some sort of mental illness, mental disorder that keeps them from being able to understand the process. And it's a different bar than just maybe having a mental illness. People can be suffering from symptoms of a mental illness, but still be able to aid and assist. We see that all the time. People will say bizarre things, and then we'll go, well, can they aid and assist? They said something really bizarre. And then we'll flesh it out. We'll have them evaluated. And then it's like, well, they say bizarre things, but they understand the legal process. So we're going to proceed. And so that's how we go with that. If a person cannot aid and assist, we cannot go forward. We cannot hold them liable for their crimes. So the process for that is somebody notices it and says, hey, this person, we think they can't understand the process. And that triggers a whole process through the court where they order an evaluation, they have them looked at, and then the evaluator will say, I don't think they can aid and assist, or I think they can. If they cannot aid and assist, the next step is to try to restore their competency. We're going to put them through legal skills training. If the person is violent and can't be restored in the community, like through TFCC, well, TFCC is our agency who we get involved, but if they can't be restored, like can't go be released, get out of jail, and, you know, get resources within the community, then the next question is, well, should they have hospital level of care? That means Oregon State Hospital. Up until a couple years ago, we relied solely on the Oregon Revised Statute related to those issues. And it gave strict timelines for, and what levels of crimes. So, you know, your low level crime, B and C misdemeanors, those are the really low levels of crimes, weren't going to qualify typically. And then you get into your A misdemeanors, which are higher levels of crimes, not always person crimes. And then you get into your felonies. We had a federal court order that came out that's basically said, no, can't do that. Your timelines are too long. You can't hold people in the state hospital for all these reasons. So now what we're faced with, we call it the Mossman order. And it's created all kinds of problems because we'll see somebody in our community and we're like, they need to go to the state hospital, but we can't get them in. Either the crime level isn't high enough or whatever. And so that has turned into a major battle. So here's what I'm seeing a lot of now. A lot of people who trespass, who commit disorderly conduct, who are terrible, they're terrible in our town. You know, they make you feel uncomfortable. They're just causing havoc. And maybe it's somebody that I know of that I've seen come through my system. And I'm like, well, we know that person. And we know a lot of people, you know, by first name, immediately by sight. We just learn these people. Some of them, we don't even need the defense attorney to go, I have aid and assist concerns. We just look at them and we're like, yep, just go get them evaluated, see if they're okay now. And I hate to say revolving door, but sometimes it kind of is like that. So there is a real cost, a very actual fiscal cost. You know, the state, whether it's defense services that pays for these things, may not come out of the county's budget, but it's taxpayer dollars that are paying for these evaluations, for all the treatment at the state hospital, all of this stuff. So there really is a cost benefit analysis sometimes, and looking at somebody who got arrested on criminal trespass, and I know that they historically have had issues with competency, and I know that the law is not going to allow us to send them to the state hospital, and we don't have the resources, and we're not going to make the state pay $4,000 for an evaluation when the maximum sentence on a trespass is 30 days anyway. So what ends up happening is I don't file charges on those because I'm like, well, the cost benefit analysis just doesn't work out. What always happens, always, is those people usually always, whatever, don't quote me. A lot of times what we see is those people end up committing one of those crimes that gets them sent to the state hospital. And now I file charges. And then they go to the state hospital. And you know what? Oh, I haven't seen so-and-so in about 6 months. You know, check your court dockets. They might be on my caseload. So, I mean, that is the very real thing that is happening. So it's been a major battle. What are we doing about it? Well, some of the bigger DAs, I say bigger because they're in bigger counties and they don't have real caseloads. Their jobs is just to do DA work. I have a full caseload. So my job, in fact, I was almost late because I was in court until like 4:40. So I have a very, full caseload. I practically have 2 jobs in this job. So, but fortunately for us, we do have other DAs in the state who have jumped in and are really working hard to fight these issues, to try to sort it out. And also there have been a lot of filings against the Oregon State Hospital for actually not complying with the law. So I sit on committees. I am in the Oregon District Attorneys Association. I go to all of our meetings and we all have our voices heard. And that's one of the main reasons I wanted this job. I knew it was going to be absolutely awful, but I wanted this job so that I could have a seat at the table, so that I could actually sit at the big kids table. not just the little kids table. I have a voice. It's pretty powerful. It's amazing because there's 36 of us and each one of us have an equal voice. So even though we're little Tillamook, I get to represent us all with the same voice that Multnomah gets. So I think that's cool. I get to bring our input. They actually ask me like, what's going on in Tillamook? What type of cases do you have? So that's what I'm doing about it, at least. I don't know how far we're pushing the needle, but there is all sorts of discussion and battles, and it's a long session for the legislature. So always pushes to try to change things and make it better. In the meantime, know that I am reviewing all of those and I am considering, and there's a lot of things that I hold on to, and maybe there's a situation where now we have 9 criminal trespasses and, oh, they committed a burglary, and I'll throw it all on there for later sentencing. Okay. So with that, the next thing is what goes into a charging decision. I just talked about, like, I might know somebody who I know that they can't aid and assist, and I'm not going to file charges on so-and-so because there's no point in it. It doesn't get us anywhere on this case. And so I'll put a note in my file and we'll move on. But what goes into a charging if it's not that? Well, they talked a lot about probable cause, reasonable suspicion, and I think I saw some of your eyes literally cross. Those are really confusing. I'm not knocking them. It's just those are really confusing terms. They're really difficult to explain and wrap your head around. So they have to have probable cause to arrest somebody. Technically, under the letter of the law, in order to file charges, I have to have probable cause, same standard for arrest, that the person committed a crime. But I don't like that standard because if I do file charges on somebody, well, the expectation is it's going to go to trial. And if that goes to trial in front of a jury, I have to prove all the elements of that crime beyond a reasonable doubt. Why would I file charges on a probable cause more likely than not? Like, they probably did it. I don't know, probably. When I go to jury and it's like, you have to decide with moral certainty that there's no reasonable doubt, like they committed this crime. I believe it. They did it. So why would I spend the resources and there's 5 attorneys in my office, me plus 4 deputies, and my super amazing but short-staffed support staff. I'm not going to put that extra work on them. It's taxing, it's stressful, only to end up going to a trial. And I mean, I'm not playing poker here. I'm not bluffing anybody. The defense sees my cards. This is the way the system works. Is I don't have secrets. There's this thing called discovery where anything that I'm going to present at trial, I have to give to the defense. And that's fair. That's the way the law works. I'm the state. I'm bringing the charges. I have to prove it beyond a reasonable doubt. And here's all my evidence. You get to know everything. And you should. Why should it be any other way? So if I don't have enough, why should I spend the resources? Why should I tie up the court system taking something that I can't prove? Now, they talked about, when they were talking about what's demoralizing and Nick, you hit it great, when the law changes. And that is another battle that I'm constantly dealing with. So we get the legislative sessions every year, the short session and then the long, which actually makes the statutes. But the law for me as an attorney is in case law. So we have a statute that says, X, Y, Z. And then you get the courts, the appellate courts, maybe somebody gets convicted of some statute and they say, well, the police did a bad search. So they got bad evidence. And then the Oregon Courts of Appeals look at it. First starts out at the Court of Appeals, and then eventually if it gets appealed from there, it goes up to the Supreme Court. And they look at it and they go, oh, you know what? Yeah, that's terrible. Bad search. Bad cop. No donut. You don't get that. And so then we're left with, oh, okay, well, now this is the evidence we have. And that's what makes the rule. So, and then sometimes it's, oh, poor lawyers. You get us in a room and we will take the most clear, obvious definition and make it the most muddy, indecipherable nonsense. And then we argue over it. We spend hours arguing over, like, this word in this position in this sentence makes the whole sentence mean this. Nope, it means that. very, very literally, there is a case, a court case where they argued over comma placement because comma placement actually can change the whole definition. So these are the things that we fight about. And I will wake up at 3 a.m. like, oh yeah, like processing it in my mind. The case law, the courts work year round, unlike the legislature who works part-time. I'm not knocking them for working part-time. I'm just saying the courts are year round. There's always these cases. And it's something that we think about. If we go to a trial and there's some objection from a defense attorney, it's like, is that going to be the issue on appeal? If we win this case, is that what's going to do it? And then how do we fight that? How do we make a good record in court? How do I make sure this sticks? So what they didn't talk about is, let's say the appellate court says, yeah, that's a bad search. The cops can't do that. And I've got 10 other cases where the cops did a search just like that. What do you think happens to these 10 other cases? They're crap. They're crap now. It means that whatever evidence, if they use the same type of search method, here's a great example. This is the best example I can come up with. The federal courts still have this exception, but everybody knows you got to have a warrant to search, right? That everybody should know that. That is one of our constitutional principles, the Fourth Amendment. Got to have a warrant or an exception. There are actual exceptions to the warrant requirement that are very limited. It's those exceptions typically that get us in trouble. Sometimes the warrants get us in trouble because our warrants, the biggest challenge is our warrants are asking for too much. You're asking for way too much. You really only need that. And you're asking to go into all of this. No, bad search. So, but then as far as the exceptions go, one exception that we've relied on for a really long time is called the automobile exception or the mobile vehicle exception. Under federal law, that's still good law. It came from the Prohibition era where people would hide booze in their under the seat or cut out the seat cushions. There's a case in point, I think they were cutting out the seat cushion and hiding the booze in there. And the idea is that, well, the car's mobile, so the evidence can literally drive away. So we have an exception. You don't have to get a warrant if the evidence can drive away. It's in a car, drive away. Well, Oregon had that for a long time until 2 years ago? I feel like I keep saying 2 years ago. So it's give or take in the last 5 years, because I can't keep up. A year feels like a week in my life. Oregon court said, no, we came to rely on that as a per se exception. And Oregon courts were like, no, the idea was couched in exigency, that if your evidence can literally drive away, then there's exigency, but you officers have to explain that. So what happened is all these cases where they searched a car and they were relying on that automobile exception as the warrant exception and didn't have a warrant, and they got all this evidence to prove all these charges, and we had this beautiful case, and we were going to, throw the book at them. All of a sudden, all that evidence was just bad, and so we couldn't use it. And that kind of answers your question. That's demoralizing. When you know you have what looks like a solid case, he done it. There's the evidence. You can't use any of it. And you have to okay, now what does my case look like? And you're like, oh, it's awful. I don't have a case anymore. That's the part that sucks, because they're guilty.
10 minutes.
Well, okay. But they did it. I can't say guilty because you're not guilty until you've been proven guilty beyond a reasonable doubt. But you know that they did it, and now you can't do anything about it. You just have to go talk to the cops and be like, well, guys, go try again. We screwed up again. For what it's worth, the courts are in favor of defendants. And it makes sense. Think about it. Think about what our country was founded on. We didn't want the government in our stuff. Stay out. You can't come in my house. Get a warrant. That's what our country was founded on. You can't search that. You don't have a reason. Go see a judge. So I love that. And I'm happy to enforce that. But it is demoralizing when somebody did something terrible and you can't hold them accountable, because And especially when the law was good at the time, the cops weren't bad. The law was good. And then all of a sudden they changed the rules in the middle of the game. You're like, ah, that happens all the time. And so then cases get dismissed. So sometimes all of a sudden we've been holding somebody and we're like, you know, let them out. Can't hold them. We don't have a case. What are we doing about stuff like that? That's one of the big things I want to talk about. What are we doing? The thing we're doing is training, studying, reading. I love being a state attorney because there's only 5 of us in our office and we're tiny little Tillamook, but we have got a huge network of district attorneys and the Attorney General's office. One of the big functions of the Attorney General's office, their criminal section, is to assist district attorneys, to come assist us. So I can call them for expertise. I called them, I took office as DA and had 4 murder cases. Holy crap. I'd never tried a murder case. I didn't know what I was doing. I think I had one in the pike that I had been working on as a second chair when I became DA. And I was like, and for me, I was like, well, I don't know what I'm doing, but I know people who do, and they'll be more than happy to come teach me. So I made the call and I'm like, I need people, I need help. And they came and they helped and we got convictions and they were rock stars. So for that reason, we reach out to those people. We reach out to other people who can help us. We get the trainings. We had DOJ, their senior assistant attorney general who literally writes the book on search and seizure law, who writes all about like searching phones, digital evidence. He came down last week and presented a training for us. No cost to us. That is their job. That is what the legislature funds them to do. So they came, presented a training to all law enforcement. He'll come again because not everybody can go at one training. But they write these books and these manuals, and our search and seizure manual is 555 pages. Thank goodness for Control F. Thank goodness. But there's other resources there, and we share them with the police. We started last year hosting quarterly trainings with our local law enforcement so that we can say, hey, we're getting this information. We get weekly legal updates. So every week it's like, here's the bad news for this week. Here's what you can't do now. No, it's not all bad, but we work with them. We're like, hey guys, law changed. And sometimes what we see going on, we're like, hey, looks like they're starting to push back against this one issue that we always thought was good. So we tell the cops, like, let's be really careful about this because we're looking in the crystal ball and we think that what you're doing now might be bad later. Maybe find another way in. Maybe do something a little different. We have been working really hard to have solid collaboration between all of us in law enforcement. We don't always have the nicest conversations behind closed doors, but we hash it out. And I appreciate all of our leaders in law enforcement because I don't think we're all type A's. None of us is afraid to be like, you suck, do better. And then we're like, we get mad and then we're like, okay, well, let's work together. But that is what we're doing is we are all working together and trying to learn so that we can adapt with the law, wrap our heads around it, understand it, so that we can make strong cases. I'm gonna run out of time.
You have 5 minutes.
I got 5 minutes.
If you want 20 minutes of questions.
Why don't I do that? Because I really just wanted to touch on those things, but I want to make sure people have a chance to ask questions because we only got through half the room on the first round. Although I chatted with them and told them to raise their hand and nobody did. So they either didn't read their chat, but if you guys can hear me online, if you want to raise your hand, then we'll make sure that we get to people online.
So let's see a hand if everybody has a question, just to give me an idea of how many doing questions from behind here. Hopkins, you don't have your question? It's okay. Okay, we have lots of time. Okay, Holly, you're first.
It's really nice to meet you, Aubrey. You seem like a really outstanding woman. It's nice to have you in that position. And Troxel as well, and Sheriff. One of the first things that you stated was that an arrest was for an offense. And I feel like, we all have opinions on what should and shouldn't be a crime. But if all of those opinions became illegal, then tomorrow we're arresting people for a shopping cart, let's say. So from the people's perspective, that really hasn't been what my experience or this many stories that I've heard in the community. The cops arrest first and then, oh, shouldn't have done that. But at that point, the damage has been done. Whether it's the seizing of property, the arrest, where time is lost, job is lost, money's lost, maybe home is lost. So there's a lot of things that are contributing to kind of what's going on in the community. I think the homeless issue is getting worse, but if we continue to keep pushing it away and not deal with the actual source of the problem, it's just going to build up and then spill back onto the streets in massive, massive amounts, worse than it is now. So I guess what I just wanted to say is your positions are so important. And I think the more we focus on the tiny details of the shopping carts or this or that, we need to have compassion about what we're seeing in the community and focusing on those little things, arresting people for these small, tiny things when there's sex trafficking in this town, when there's drug trafficking in this town, and we don't hear anything about that. We need people like you and officers and the people in power to kind of shift the focus, in my opinion, because it's, in my belief that you can't follow rules and ethics. It's one or the other. So if something comes across where you guys are to be arresting people for, having a shopping cart, yeah, they took what they didn't belong to them, but they're homeless. They're using it to transport their goods. You guys want to volunteer and swoop it up and maybe give a ride somewhere? That's what my vote would be, but not arresting people for silly stuff like that and taking the authority to shift their focus. My one question is, why isn't OSP ever at these gatherings? And thank you for what you guys do. Appreciate it.
You know what? I don't know that we included them, which would be our fault.
Well, yeah, and OSP has a different command structure. Most likely, they probably would not authorize their local sergeant to come and speak on their behalf. Like the lieutenant for the Tillamook office is actually based out of Astoria. So their dynamic is different, and the main driving factor for this is Aubrey and I are elected. We answer to you guys. I mean, OSP technically does, so does Nick, and so does his officers, but we truly do because we are elected by you. So that was one reason why her and I kind of drove to this.
Well, the OSP superintendent is chosen by the governor. You know what? The next one we do, I will make sure to reach out to OSP and let them know that we're doing this, because we did reach out to Manzanita.
Prior engagement. So
Okay. I mean, this is like what we'd love. I think all of us would love to do more of these. Sometimes it's scheduling and just being downright busy. I would love to touch on what you said. And I think that's a good point, a good perspective, because there is that perspective. I hear a lot of negative of like, the DA is never doing this. And so I want to talk about what I'm doing. But I think it's a good point to also talk about, because we have these discussions among us attorneys. I hired a new attorney year and a half ago, and she's like, are you guys really going to prosecute for just like if somebody steals like a drink at the Center Market? And I was like, yeah. You don't walk into the Center Market and open the cooler and take something like it's your personal fridge. But some people are like, that's a petty crime. So we talk about that, and I'm like, well, sometimes there are things, and we literally are like, this doesn't merit prosecution. Sometimes that's why I mentioned earlier, there's a peacekeeping function. Sometimes the only way to stop the thing in progress is to make an arrest. But I know they talked about the citation in lieu of custody process. So, and a lot of times that's super appropriate. Here's a ticket, come to court if the DA files charges, and you don't have to go to jail. So there are those, but a lot of those quality of life crimes that we're seeing there are underlying issues. And I think what's not publicized, what you're not seeing is a lot of times we get those situations and we do learn about some of the underlying issues that are causing homelessness, that are causing people to be addicted to drugs. We get involved in their lives whether they like it or not. And, you know, we end up, a lot of times they go through the court system. And this kind of touches on your earlier question about, you know, what's happening. Sometimes if it's, we don't yet have what's called the deflection program that's authorized under House Bill 4002, which was the bill that recriminalized drug possession that was decriminalized by ballot measure 110. We're having discussions surrounding that to see with that peer support, if we can actually meet people at that level to keep them out of jail. That's the idea behind that. There are all sorts of services in our community, and police know it, like TFCC and their ACT team and their crisis. So, and there's other options for people when they see them doing something to really get involved with them. I would say, just from what I see, I do see every single arrest that goes to the jail. Sometimes a lot of them I don't charge, because I'm like, well, they were keeping the peace and I don't see any reason to further this. There's no reason to drag it through the court system. But a lot of times we are seeing, sometimes there are those petty things, but sometimes it's like, well, if we let one person walk into the center market and steal a bottle of Gatorade, then so does the next person, and so does the next and the next, and now they're stealing a case of Gatorade, and now the center market goes out of business. And now a family that was working really hard to have their own business and provide, you know, who wants to see center market go out of business? I don't. So that's kind of the mentality there, that snowball effect, if you will. So that's something that we have to consider, but those are very good points. There are things that are like, you know.
I think each situation is different as well, because the person, I'm not aware of people getting arrested for one. I know that the city is just collecting them and getting them back to the places, but you know, you may not know the history. Maybe the person that's stealing that card has been warned 6 other times prior to that, and we have no other choice but to stop the action. I would also say that we have an equal obligation to be compassionate to the person committing the crime as we do to the victim. You know, so it is a fine balance, and like I said, I'm not aware of people just randomly being taken to jail just for the fun of it, you know, and for one card. So I think we are compassionate. We take in all factors, but thanks for bringing that up.
Do we have any questions in this room? Okay. Go ahead.
Yes, well, first of all, I just want to recognize all of you have a very hard job. You're in law enforcement, or we have to go about the business of convicting criminals in our county. I understand that. That's where society, at least the criminal failed, the family has failed, churches have failed, we have failed as community. I understand that. However, and I understand the law has changed and it's terrible in this state. We've got to get back to common sense, where the Constitution of Oregon says, yes, we are going to recognize that the law should be holding people accountable. We are not doing that. You cannot do that with drug addicts by enabling. You have to give them a hand up. And I know this personally, and the law beings who know that. But my question is when I watch those people come in with charges, and then before they're even given a chance for a plea deal, those charges are getting lessened. And they're serious crimes, sometimes against children. It is very discouraging, disheartening, and a little scary. And I'd really like to understand why we would consider doing that when we could at least keep that charge up to a level that maybe we can negotiate then when they do make a plea deal. It's very infuriating. And I also just want to say, I'm sorry, I'm rather shocked that we are giving prisoners I have to understand it's limited if they're with program. That's super unnerving to me. Again, I don't want anyone to like suffer hunger or violence in jail, but my goodness, jail should be unpleasant.
I want to make sure I'm understanding your question. It sounded like you were saying you're concerned that the charges that are originally put on them are higher than are you saying the charges that they're being held on in the jail?
Yes.
And then I'm filing lower charges. Okay, I can definitely explain that. So here's a great example. I saw, okay. Officers have to have probable cause to arrest for certain charges. Officers, while we do trainings with them and they have their own trainings, we're not required to train them. That's just something that we're trying to do to collaborate. They have their own trainings, but we attorneys, we are trained through our law school experience and then our additional training that we have to keep up with, and especially as prosecutors, we are living in the weeds of the laws. So sometimes they arrest for something, but we can't charge it. And I'd have to give you specific examples, but I can definitely give examples, and I've got it the other way around. I had a guy recently who was arrested for disorderly conduct. He was booked and released. He had gone after one of his neighbors with a 2x4, and I charged him with attempted assault in the second degree, which is an attempted measure 11 crime, which he wouldn't have been released at all for. So it is the other way around. So we are the ones that are specially trained and skilled in analyzing the actual law and looking at the facts and applying to the law, but also looking at that case law. So they might look at a statute, but they might not know about that case that came out last month that says we have to prove this. Also, a lot of times, and this is something I have been working really closely with law enforcement on, and this is something the public's not usually aware of. When they hold somebody in the jail, they have to fill out a probable cause statement, a declaration basically, to establish their probable cause. And, you know, a lot of times they're in a hurry, or it's late, or they're just trying to put that one paragraph in. They know they've got to write a full report, and they don't cover all the elements of some of those higher charges. And so when I look at it the next morning, I'm like, there's not enough here for this charge. I need more evidence. I'm going to hold them on this, and then we're going to go to we'll go to grand jury, or we're going to call them. So there's a lot of what we do as DDAs is hounding the officers for, give me this evidence. So-and-so said they have video. Make sure they get you that video. Is there video the Safeway doesn't have video at their parking lot, but give me the video from Fred Meyer. Give me this, give me that. Is there body camera? Who said this? Who said that? There's a lot of that. So it's not that we're trying to reduce the charges out of the gate, because we're going to charge the highest level charge that we can. I think sometimes the officers hold them on higher charges than they can.
Do you have any questions? April, are you talking about the charges that they're held for or originally charged with? Or are you talking about plea deals on the back end? I thought you had mentioned plea
This is
deals.
like before they even make the plea deal.
I think she's saying that, like, because you guys look at the jail rosters, it sounds like, and you're seeing what they're brought in on. And then it sounds like you're checking maybe the e-court and looking at what we're actually charging. And especially when you look at the serious crimes, I mean, we got to go to grand jury on felonies. And so we're gonna charge the highest level of crime that we can prove at trial. And again, that goes back to my discussion earlier of probable cause to hold beyond a reasonable doubt at trial. So they might have probable cause, but when it gets down to it, I don't have enough to be able to prove it at trial. And so I can't charge that. And I have an ethical responsibility. So there's just a difference there. And we work with them. Yeah, sometimes I see stuff that they don't actually have enough to hold them on for that. I see it across the board.
Well, I don't think so. There's any question. Yes, Rose?
Yeah. My question specifically towards the PJO and releasing inmates. Is there any way you can appeal those? Like, let's say somebody's in for domestic violence and the PJO says a week later, like, I'll release them. Is there any way to appeal to that and be like, they're a danger to their spouse if we let them out right now?
That's actually a good question that I would have to answer. So if somebody is, there's that pretrial release order, the presiding judge order that affects pretrial release that's based on the Chief Justice, that's based in the law, all that is pre-charging. Once we file charges on somebody, then we go to court and that person is they're held to answer is what it's called, and we have arraignment. And the court can take up release. And the release assistance officers often go interview and they do this whole background to see, like, I'll just say it this way. The law leans toward releasing people and allowing people to actually be released. And we look at that and one thing that, again, enforcing rights, all crime victims have the right to be heard at a release hearing. So if the court takes up release at arraignment or any time, a crime victim has a right to be heard. And the law actually requires, like even before the arraignment, I see a lot of times on the paperwork from the release assistance officer that they reached out to the victim. So I routinely object to release. If we haven't heard from a victim to give their statement, I'll object to release until we can get the victim there to be heard. We have a victims assistance program. I have 2 full-time victims assistance advocates whose sole job is working with victims and connecting with them and trying to get their input, because we take that very seriously, making sure that their rights. So if there is a domestic violence victim who's concerned about public safety, then now DV cases cannot be released. They're a hold until arraignment charge. So somebody, even if it's a minor harassment, if there's a DV element, they're not getting released. I don't care if it is Friday on a 3-day weekend, they're not getting released. They're going to be held until arraignment. And then at arraignment, the court's going to take that up and find out, get the input from the victim.
Can you explain arraignment? Just what is arraignment? When you get arrested, arraignment?
Arraignment is the first court appearance where people are held to answer for the charges. So they get arrested, I review that probable cause declaration that they fill out, and hopefully they've gotten me reports super quick. And I review all of that. I make a charging decision. I file initial charges. Even if it's a felony, I can at least file an initial charging document to continue holding them on those charges. And then we go to court, where it's the very first appearance. They read the charges, they read them their rights. A lot of times a person has an attorney, and the attorney will waive the reading of those rights and then tell it to them later. But that's when the clock officially starts on their case.
How soon do you have to be arraigned after you're arrested?
That's a great question. If you are not released, you are required to be arraigned within 36 hours, excluding weekends or holidays. So if you get arrested on a Friday, your arraignment's going to be on a Monday. If Monday's a holiday, Tuesday. There is a rule that requires, a law that actually requires, if somebody's going to be held more than 48 hours, then there has to be a judicial review of probable cause. So we deal with those every single weekend. On Sundays, we all work to review arrests. If you are booked and released, on one of those categories that allows release, then the law says you have to be arraigned within 96 hours. So the court holds arraignments every single day, 4:00 and 4:15 is when the arraignments are.
All right, any more questions in this row? Okay, let's move to this row. Hopkins first.
Okay. So officers will often call the DA's office for advice on what to do, basically. Are there scenarios where the DA's office will recommend not effecting a PC arrest? And if so, what factors are considered, like your burden of proof, speedy trial, impact on the victim, et cetera?
That is a great question. For those of you who couldn't hear, Jason Hopkins asked, sometimes officers in the field will call me or one of the other DDAs. We do have an on-call line that's monitored 24/7. So they will call us and say, hey, this is what we've got going on in the field. And they'll ask us for our input on whether they should make a probable cause arrest. And there are times when we advise against officers have discretion on making an arrest. I cannot tell them, don't make the arrest, but we can encourage them not to. And there are reasons why we would do that. Let's say you do have one of those sex trafficking cases. Okay, thanks. Maybe you have one of those serious sex trafficking cases or something like that. And they might have probable cause, but we have things that we need to do for the investigation. And maybe they don't know they're being investigated. Maybe there's, we go through a whole series of things like, is there a current risk of safety to the person they are accused of victimizing? A good example of that is maybe an abuse case where the alleged abused person is no longer in the home and the accused or soon to be accused is not living with anybody, something like that. And maybe we want to do more searches. Maybe they're trying to get a search warrant for Facebook. Maybe they're trying to get a search warrant for whatever. I don't know. Something that's going to take a long time in our investigation. The thing for us is and Jason hit it on the head, is when the person's arrested and we file charges, our clock starts for speedy trial rights. So there's a statute of limitations for how long we have to file charges. And that's the greatest amount of time. And it depends on the type of crime and the severity of it. But once somebody is held to answer, my clock speeds up. And if a person is held in custody, they have a right to a trial within 60 days. Well, I don't want to take somebody to a trial in 60 days if I'm going to have a really weak case. So we do that analysis together of like, okay, this is what we've got, this is what we're working on. You know, maybe it's in the best interest to hold off on arresting until we can gather our evidence and present our case to the grand jury, get an arrest warrant, and then boom, we have everything we need. We're ready. Let's go. Versus, oh crap, I'm not ready, and they want their speed.
Our last question, Edie. Yeah.
So related to that, and particularly related to children and like our most vulnerable populations within our community, is there a case law that prohibits trying somebody like with probable cause, or what does that look like in terms of, because you mentioned, and this is like a help me understand, you mentioned like the probable cause case and then the next layer level beyond a reasonable doubt. What's the like transition between those? And then also like what's the DA's office's like connection to like child safety or safety within kids with information?
It's so loaded, and I've got 4 minutes to answer all of that. I'm going to start with your first question, PC versus beyond a reasonable doubt. Under the law, I'm only required to have probable cause that a crime was committed to file charges. But at trial, I have to prove it beyond a reasonable doubt. So we like to use math because those are fuzzy phrases. So we say 51% is probable cause. Somebody 51% more likely than not did something. Versus they did it and there's no reasonable doubt they did it. I can give examples, but yeah, hopefully that helps for now. It's just I need a lot more to prove something happened beyond a reasonable doubt and versus probable cause, you know, like, okay, here's a great example. So this, because I see this all the dang time and it drives me insane. So-and-so person A saw person B and they were driving a truck, and that truck looks just like the truck that, you know, the other person's brother just reported stolen. And I even see a scratch on the truck. It has to be the same truck. It has to be. Probably. But for a trial, if you're a juror, well, what, isn't there more you want to know? What's the make and model? What's the VIN? Did they find the truck and find that it was the same VIN or the same license plate? Were there other identifying factors? So you want it to be concrete, you know, so if something, that probably happened, but you don't know for sure, you know.
Then is that part the piece, sorry to like spark note of that, is that part for like, does the jury for that part, or is it the DA's office, or how does that go? So like say that was like people, okay, person A did something to child A, and you know, like that part, kind of the car scenario, but actually with people, what does that look like? Or does that?
So the jury is going to make the ultimate find. So I can look at something and say, yeah, there's probable cause that this happened. I might be able to prove it. Let's just see what happens. But it's ultimately going to go to a jury, or if a person waives their right to a jury, it'd be a bench trial and the court would decide. But most times we rarely see a waiver of jury, but most of the time it's going to be a jury. And so if, you know, when you're looking at a set of facts and you read about something, think about, well, is there anything else you want to know? And do you need that information? What more do you need to be able to say that person definitely did that? But it's the jury that makes that call. I review it to try to determine, in reviewing like prior cases, how do things work in our courts? What have the appellate courts said about a particular, because their appellate courts can come in and be like, oh no, a reasonable juror shouldn't have been able to find that. So I weigh all of that to see, is there enough based on my experience and my level of knowledge of the law so that a jury could in fact find that.
Sheriff Brown.
Does that answer it?
Is that okay? I was gonna say 30 seconds for a final statement from Sheriff Brown. Everybody get a shot and we'll wrap it up.
All right, thank you for coming. Great crowd.
I didn't get to answer last, Sarah. I'm sorry about that.
Chief Troxel, did you have something you wanted to finish with?
No, let's keep the momentum going and see you again.
Round of applause for Troxel. Olson, and, I think that went well, and I'm sure they'll do it again.
He said he drove around a lot, like 10 times and could not finish.
I would have known that.
Yeah.
Can we get more than an hour?
Right now, it's not a long time.
First of all,
I'm an able body.
Back door.
I'm partner right there. It's not, it's a.
Okay.
My son has her.
There's a red dot. That's what I told her. I was telling her.
He had a cat. No, you don't. Actually, that's all he had. Is dog. What? That maybe happens with the and we're with my house to do wouldn't have picked that. That decision and I had a
So we're.
But so that kind of stuff is like, that might not solve that problem because I can't, and then when she
Hey.
so I think that, so we did that.
You're done.
That's a good point. Yeah, that's a good point. I'll,
Policy at this point, because I know that she's. I don't know, name.
because it's a lot of.
Only two, but we'll stay off. We're like.
Well, in my, I love you.
I pushed the ball on my life. I said, no, sure.
I will say, I'm still gonna have to speak to my boss today, and when I took office, it was out. And I don't think it was out. I don't want to change. Yeah, I get it. I understand. So I'm like, I want to get that information out here. And I'm all, my
oldest
is I have to.
We had to find it.
That is a.
Oh, no.
So I will definitely.
Have choice. Look for things.
It did. Okay.
Trying to get him shut down. I'm just making sure we're all good. We don't want to go out to dinner, I know.
Okay. Sure.
I know.
Yeah, my
Are you
thought.
saying, are you saying that she never went to jail in the first place, or she got arrested, went to jail? That is one of the things.
Because it was a little issue. She was standard. And then just over. They set up off the rest of it.
Yeah. Really distracted.
I used to have somebody just doing this over here. We always had a house right next to them. Right there, the sign gets taken out. We want this, especially with the speed sign. Black chain link.
I didn't know she got. Do you know? Things on.
I was thinking about that just today when I was waiting.
Like, this is not like, I know, I understand that. I'm gonna. Yeah. Oh, I just feel like she was. So that's. Without a clear. Yeah.
Fly back to work. Walking out the only parts.
I have that take care of. I don't understand. And trying to get everything together. Thank you for coming back.
She was living out.
We thought.
Maybe some wrong person to walk by.
Sorry.
Somebody's off.
Still be alive.
One thing.
Now. Where I was. That's what we want. Stay home. And if I don't know. Thank you.
So I do a little bit, but once I get.
Yeah. Yeah. All right, guys, we gotta wrap up this area. More than welcome to talk outside, but we do gotta get the one employee home that stayed an hour late for us. Sure.
Not appropriate. I know, I got called out.
I did.
I knew. Well, they're like, who is she? And I was like, oh, who is she? Ooh, let me tell you.
They will take care of you.
Back there.
Yeah.
Say hi.
Doesn't need to stop by.
They'll take care of you.
Yeah, I might say hi for you.
Okay, I need to shut down.
Oh, okay.